Welcome back.
Thank you, Chairman Lathrop. Good afternoon, Chairman Lathrop and Judiciary Committee. My name is Justin Wayne, Justinwayne, and I represent Legislative District 13, which is North Omaha and Northeast Douglas County. Sometimes our laws and our courts get it wrong. We have to look no further than DNA exonerations, separate but equal doctrine, and juveniles being sentenced to life prison. As lawmakers today, we have a chance to get it right. LB28 allows an individual to file a motion for a new trial when evidence that is constitutionally barred from being presented at the time of trial becomes available after the trial. Today you'll hear testimony about Ernest Jackson, but this bill is not about Ernest Jackson. In fact, Ernest Jackson is an example of the injustice happens if we do not pass LB28. Ernest Jackson is a byproduct of a failed process. In order to understand this bill, I have to first mention the Fifth Amendment. And I'm doing this so many of the non-attorneys on this committee kind of understand the background. The Fifth Amendment basically says no person shall be compelled to testify in a criminal proceeding against themselves. So essentially this means as a defendant, if I ask somebody to come testify and they take the Fifth Amendment right, that never gets in front of the jury. So that evidence is never heard. But afterwards, after your Fifth Amendment privilege is no longer needed, say that person went to trial and they were found innocent, that privilege is no longer there, so they can now testify. Or if they decide to testify in their own trial, they waive that Fifth Amendment right. But prior to waiving or being proved innocent, that testimony never comes in front of a jury. So essentially this bill will allow evidence of that testimony if a new trial is granted, and the key word is if a new trial is granted, to be heard by that jury. What you'll hear from the county attorneys today who are against it are basically two essential reasons. One is the county attorney and judicial efficiency, and two, when they talk specifically about Ernest Jackson, they'll say he can apply for a pardon. And I'll tell you why I think both of those are not fair. First, judicial efficiency. Our system is not set up for county attorney efficiencies or a judicial efficiency. In fact, our judicial system is set up for justice and only justice. This concept was first laid out in 1760 by William Blackstone when, in summary, he says, "It's better that 10 guilty men go free than to convict one single innocent man." And if you think about that, you think about the presumption of innocent, you think about the requirement of proof beyond a reasonable doubt, you think about the requirement for a unanimous jury verdict. These are the core elements of our criminal justice system, and they all directly flow from the premise of a wrongful conviction of a single innocent person is 10 times worse than the guilty person going unpunished. Where do we find that? We find that in our founding documents. Declaration of Independence says, "We hold these truths to be self-evident that all men are created equal and that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness." And in fact, this document mentions rights over 10 times. The preamble of our Constitution says, "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity." And we have to look no farther than the Bill of Rights. The rights to be free from unlawful search and seizure, the right to remain silent if wrongfully accused, the right to be represented by counsel, and the right to a jury trial. We focus on the individual because we have founding documents that say the community is best served if the individual right is best served. Today, the county attorneys will ask you to ignore our core constitutional rights and care more about county attorney and judicial efficiencies. And again, I must say, the judicial system is about justice, about just outcomes, not county attorney or judicial efficiencies. And to make that argument goes against their own constitutional duties and is completely wrong. This bill is to say that if you find evidence that is constitutionally barred from being presented at trial and it becomes available after trial, you have a right to file a new motion or a motion for a new trial. That does not guarantee you'll get one. You have a right just to file it. And that evidence also has to be material, and that is up to the judge to decide if it's material. The county attorneys will bring up, and you'll hear testimony about Ernest Jackson, but they'll also bring up that Ernest Jackson can get a pardon. That argument is misleading the point. First, a pardon says you're guilty and the crime and your actions were wrong, and we forgive you as a state. That's not justice, that is forgiveness. This bill is about making sure our judicial system is just. A just judicial system is about allowing someone the ability to prove their innocence rather than ask for forgiveness. This bill is not about that particular case, but people who can end up like in the situation of Ernest Jackson. I must also make a note that last year Chairman Lathrop introduced a bill, a priority bill, and I went to him last session, I guess it is last year, and I asked him to introduce this exact amendment, to have an opening and a small discussion, and I'll withdraw it. And I signaled to all the county attorneys this is an issue that we have to address. I did my opening, talked to the county attorneys, lobbyists, and the County Attorneys Association, but since then there's been silence. There's been no back and forth of how to tighten or narrow this if they have concerns about opening the floodgates. And in fact, it's just been a refusal to do anything. We have to demand better, and we should be better. This bill is simple. If there is new evidence that cannot be presented to the jury and it is material, that person should be able to file for a new trial. With that, I will answer any questions.
Senator Brandt.
Thank you, Chairman Lathrop. Just a real quick question. How big is the scope of this problem? Is it more than just Ernest Jackson? I mean, are we talking, there's 10 of these out there, 100 of these out there, 1,000?
The only one that I'm familiar with is Ernest Jackson. So there are gaps in the law. Like today before you, I came with a paternity issue this morning, and you weren't here.
No,
but it was a bill that we passed last year. That was just a case that I ran across, and since then there's been at least 3 other cases that I've been contacted to by an attorney. I don't think the problem is very wide and narrow, but it does come down to justice. And I think we as a judiciary, I'm no longer on the judiciary, but I used to be, but we as a legislature should provide the tools for justice.
Okay, thank you.
You'll stick around to close on this one?
Yes, sir.
Okay, terrific. First proponent. Welcome.
Good afternoon, Chairman Lathrop and members of the committee. My name is Tom Riley. I'm the Douglas County Public Defender, and I am here also representing the Nebraska Criminal Defense Attorneys Association as a proponent for this bill. I agree with Senator Wayne's statement that this is not just about Ernest Jackson. This is a remedial statute to try to fix a interpretation of the statute that was rendered by the Nebraska Supreme Court in Ernest Jackson's case. And in order to understand it, I'd like to put a little bit of background into his case. Basically, Mr. Jackson and 2 other individuals were charged with homicide as being aiders and abettors to each other. The cases were not consolidated for trial. I represented an individual named Shalimar Cooperrider, who was one of the individuals charged, as was Mr. Jackson, as was a man named Dante Chillis. So as I said, the cases were not consolidated for trial. And the way it works is whoever got their case filed first would go first to trial. Who was the case that was filed second would go second, and third would go third. And these were all filed on the same day. It just happened to be Jackson's was first, Cooperrider's was second, Chillis was third. So Mr. Jackson went to trial first and indicated he was not present at the shooting. The jury found him guilty. He requested that our client testify. However, our obligation is to our client, and we asserted the Fifth Amendment because we didn't want to give county attorney's office a free shot at him before his trial. So he went to trial second. He testified that he did in fact do the shooting and it was in self-defense. The jury found him not guilty. The third man went to trial thereafter, named Mr. Dante Chillis, and Mr. Cooper Ryder testified at that trial in the same fashion that he did at his own, and Mr. Chillis was also found not guilty. So basically by a luck of the draw, bad luck of the draw, Mr. Jackson got convicted. On his appeal, the lawyer said, now that he's testified, the Fifth Amendment doesn't apply, so it's newly discovered evidence under the statute as it was written. The Nebraska Supreme Court said, no, it's not newly discovered evidence, it's newly available evidence and does not fit into the statutory requirement, so we're not even going to consider it to give you a new trial. This statute, LB28, is there to remedy just such a situation. And there have been a handful of cases that had similar situations. I had another case myself where there was a co-defendant and I tried to get him to testify, and he asserted the Fifth Amendment, and it would have helped in our defense, and my client got convicted. So this bill is a remedial statute to fix something that I think the Nebraska Supreme Court determined incorrectly, and you have the power to change it.
Okay. I do have a question. And just for the benefit of everyone, if we change this, and somebody made a motion like this, the court is going to have to make a decision that it would have made a difference.
Right.
It's not everybody who had somebody take the fifth that was a co-defendant.
No.
There is some judgment by the trial court.
Absolutely. All this does is allow for a person to file the motion and say, here is the evidence I was not allowed to present to the jury. Judge, you determine if it's material and exculpatory and would change the outcome of the case, and if the judge believes that is the case, then a new trial would be granted. This is not a exoneration type bill, and it is not you automatically get it. The judge that hears the hearing on the motion for a new trial would be allowed to consider that which was previously constitutionally barred and what the testimony of the person who no longer has the Fifth Amendment privilege. And then the judge would say, okay, this is not going to change the outcome of the case, you're not getting a new trial, or yes, I do think this is very substantial and there's a likelihood the result would be different, and we're going to give you a chance to present it to a jury.
Okay. Senator Brandt.
Thank you, Senator Lathrop. Real quick question. Is this unique to Nebraska? Is what's happening now unique to Nebraska, or all the other states like Nebraska?
I can't answer that question. All I can tell you is that the statute that we have for granting a new trial is the one that was interpreted by the Nebraska Supreme Court and said it was newly available versus it was newly available, not newly discovered. There is a paucity of cases on this. I have done some research on it, on that other case I told you about, and there wasn't a heck of a lot out there.
Okay, thank you.
Okay, thanks for being here.
Thank you.
We appreciate hearing from you. Next proponent. Good afternoon.
Good afternoon. My name's Janelle Folkerts, JANELLFOLKERTS. I want to thank good afternoon. I want to thank Senator Wayne for introducing this bill, and I want to thank this committee for listening to my testimony today. I know several of you on this committee personally, and you might be wondering why I am here testifying in support of this bill today. I am here today to support Ernest Jackson, who is wrongly convicted of a crime he did not commit, as well as those who are currently incarcerated for crimes they did not commit. I consider myself a freedom fighter. I believe in limited government and believe that more government involvement in our lives is usually always the problem and not the solution. It's because of this stance. One day last fall, I was outside this very building protesting the overbearing and unconstitutional mandates being placed on individual citizens and businesses because of COVID-19. There was a group of opponents that had gathered across the street from us. Because I am always interested in learning and understanding other people's positions and point of view, I engaged with several of the opponents to have a better understanding of why they were there. At that time, I met a young man from Omaha who said he was there not in support or against the mandates, but because he also believed in freedom like me and was there to represent Ernest Jackson, a man whose freedom was wrongly taken away. Once I heard Ernest Jackson's story, I knew I had to get involved. How can I claim to be a freedom fighter if I only fight for the freedom of those not incarcerated? Do I truly care about freedom if I'm not fighting for the freedom of individuals currently serving time behind bars for crimes they didn't commit? The answer is no. I believe in liberty and justice for all Americans. In the case of Ernest Jackson, he was convicted of a crime that another man confessed to. The man who confessed was then acquitted on self-defense. However, because Ernest's trial was first, he was convicted of first-degree murder and still remains incarcerated and has been for over 20 years. Ernest has exhausted all appeals, and his only chance of being released is to receive a pardon, which the pardon board is not set up to determine innocence or guilt, or receive a new trial, which this bill would allow. With the new evidence presented after Ernest's first trial, it's almost certain a jury would find him not guilty. I wish Ernest's case was an isolated situation. However, wrongful convictions happen far too often due to bad eyewitness accounts, witness tampering, fabricating evidence, concealing exculpatory evidence, misconduct in interrogations, misconduct at trial, as well as other misconduct by police, prosecutors, and law enforcement. According to a study by the National Registry of Exonerations, released in September of 2020, in the United States between 1989 and 2019, there have been over 2,600 exonerations. Of the 2,600, 93 innocent defendants were sentenced to death but later cleared before executed. I support law enforcement in our justice system. We need them in order to have a civil society. However, for far too long, we have allowed this system to go unchecked. Many defendants that do not have the means to hire good defense or simply do not know their rights are taken advantage of. This bill would allow us to give these defendants a chance for the system to right their wrongs. When new evidence is presented that could lead to the innocence of someone wrongly convicted, we have a duty as citizens and legislators to act and seek justice on their behalf. I'll just leave with this, a quote from Martin Luther King Jr. Justice too long delayed is justice denied, and I hope you all would vote in support of this bill.
Okay. I don't see any questions, but thanks for being here today.
Thank you.
Next proponent. Good afternoon and welcome back.
Jason Whitmer, WITMER. I'm going to cut mine in half because the facts have been stated, and yes, I will speak a bit about Ernest Jackson because I feel he is the essential of what injustice looks like when a loophole like this is not closed. As far as the bill, as was said, this does not open the gateways from prison to society. Nowhere does it lack of accountability. In fact, it's all about accountability. For the defendant has to go back to the trial if he gets trial. The courts, our justice system, accountability is what we want. In the case of Ernest Jackson, which I feel is a great example here, so that's why you will continuously hear him, his case, as you heard the facts, he did not get the testimony of the individual who did it. But one other thing that's included here is that person was acquitted of self-defense, not of misconduct of the jury. Self-defense. That means he was innocent, and that means there's not even a crime here. So 20 years for accessory to a non-crime. This loophole is a noose. Lynching is all about holding somebody accountable without evidence because somebody has to be punished. And this is what's happening to Ernest Jackson. So imagine if that happened to you, to your children, to your neighbors, to your constituent. So Ernest Jackson's been in prison for 2 decades, and because our appeals court use of language, not for morals, not for ethics, and I would argue not necessarily common sense, but language stating that this testimony, fully vindicating this child, because he was a child, 17 years old, was newly available and not newly discovered evidence because the actual shooter wanted to exercise his constitutional right, which is his right. It's language is always meant to diversify, not to destroy. So, I really don't want to, I would love to reiterate this case. You know this case. You know this case. This 17-year-old boy was crucified for saying he was innocent because he was. His family was made out for liars for telling where he was at home. He wasn't there, so he had no defense other than to say he wasn't there. He had no privilege for individuals like Don Klein or Katie Benson to give him a deal to vindicate himself. And the appeals court came to the conclusion that somebody else's constitutional right will be used against him as an executioner's act. So no one with basic decency of humanity would allow such an injustice to remain, especially if it was your own. I think this bill speaks for itself. It's very narrow language. It does not open the gates. This is a pro-justice bill, a pro-life bill. It's a bill that demands accountability. I don't know what else can be said here.
Okay, let's see if there's any questions. Before we let you get away, you have been on this, you've been a great friend to Ernest Jackson, I can tell, because you have brought this before this committee on a number of occasions. I appreciate you being here today.
Thank you, sir.
Yeah, thank you. Next testifier. Good afternoon.
Afternoon, committee. Jonathan Lathan, Jonathan. Last name is Lathan, Lathan. So thank you, Judiciary Committee, for allowing me to come speak on LB28. I'm here to speak to you today as a proponent of this bill. Although this bill covers more than just a case I'm familiar with, which is Ernest Jackson's case, I'd like to take some time to speak on this. I grew up in Omaha. I ran some of the same streets as Ernest. Fortunately, I was able to enlist in the military before I found myself in a similar situation as Mr. Jackson. I'm a father of 5, 3 of my children being boys. My oldest is 17. He hangs out with his friends, spends time with family, and plays video games, just like Ernest. I keep excellent track of where he is, but just as with Ernest, a case of mistaken identity or allegedly being at the wrong place in the wrong time could cost him 21 years of his life. 21 years away from his family, 21 years away from his friends, losing the opportunity to be physically present raising children, and losing the opportunity to be a free man. I couldn't imagine my son being taken away from me, initially based on seemingly inconsistent charges and convictions. Ernest was found guilty of first-degree murder, but not use of a weapon to commit that murder. On top of that, he is still incarcerated, even after the actual shooter was acquitted of that same murder on the charge of self-defense at his own trial. That trial just happened to be after Jackson's. Even with the knowledge that another person confessed and was acquitted of the murder, Ernest is still in jail. State law has prohibited this information from giving Ernest a new trial, basically because of bad luck. Ernest had his trial first, and his legal team asked several times for Cooper Ryder, the shooter, to testify. Those requests were denied because it could potentially incriminate Cooper Ryder because his trial was set for a later date. This is why we're here today. If Ernest had been given a trial after Cooper Ryder, the verdict of self-defense would have counted. Ernest would potentially be free. That's not the only evidence that should be considered, though. An eyewitness placed Jackson at the scene, hitting the victim on the head with a pistol. The autopsy did not show that to be true. The witness that saw Jackson at the scene didn't even know who he was until police told them who he was. There are many inconsistencies with this trial that LB28 will be paramount in bringing justice to Jackson and his family. We live in a society of second chances. We now have a second chance to make this right for Ernest and for every other inmate who may have similar circumstances. We talk about justice. We talk about how important family is. We talk about doing the right thing. Well, now is the time to do that. Vote to pass LB28 for Ernest, for his family, and for our sons, even though we are good parents, could end up in a situation to be taken away from us for 21 years. Ernest is just one example of countless others that we can bring justice to who deserve the chance to have their voices heard and deserve the chance for retrials. Thank you.
Thank you, Mr. Latham. I do not see any questions, but thank you for being here.
You're welcome.
Appreciate it. Next, proponent. Anyone else here to speak in favor of the bill? Okay, seeing none, we will take up opponents. Opponent testimony, if you're here in opposition, you may come forward. Good afternoon.
Good afternoon. My name is Katie Benson, K-A-T-I-E-B-E-N-S-O-N. I'm a deputy county attorney out of Douglas County, Nebraska, and I'm here on behalf of the Nebraska County Attorneys Association, and I'm here in opposition of LB 28. By way of background, as I stated, I am a deputy county attorney, and I've been so for 12 years. Throughout those 12 years, I have handled all collateral attacks filed in Douglas County, Nebraska, including motions for new trial based on newly discovered evidence, but the majority are post-convictions and DNA Act. Prior to that, I was a law clerk for the district court judges, where I did sit through hearings and render orders in collateral attacks as well, so I'm very familiar with the statute as well as the other remedies available for those incarcerated. Specifically with regard to LB 28, and why I'm here in opposition of the bill, first and foremost, I would ask you to really look at the additional verbiage placed into 29-2101 because of LB 28. I find that it's not very clear and it would promote confusion. Specifically, when you look at the first sentence, it states, newly discovered evidence includes testimony or evidence from a witness who previously asserted a constitutional privilege. Well, if you're just somebody opening a statute and reading that, I think even a judge would have some confusion as to where did they assert that privilege? When did it happen? Was it in the case of the person who filed the motion for new trial only and who was convicted based on that, or was it in some other proceeding? And on that, the second part of it, part of the newly amended the amendment by Mr. Wayne, it says, and refuse to testify or produce evidence in a prior proceeding. Well, what prior proceeding? A preliminary hearing, a trial, a deposition? So I think you really have to look at, if you're in favor of this in general, you have to look at this verbiage and really ask yourself if when a judge, a prosecutor, or a defense attorney, or a defendant who's incarcerated looking for a remedy would read this, does it make sense and is it clear as to when it would apply? Also, I would ask you to really consider the ramifications of what that additional language would do. And I can say it no better than the Supreme Court, who said that if you were allowed to this type of evidence in, the Supreme Court in Ernest Jackson's case said it would encourage perjury to allow a new trial once co-defendants have determined that testifying is no longer harmful to themselves. They may say whatever they think might help a co-defendant, even to the point of pitting all the guilt on themselves and knowing they are safe to not be retried. So look at the language of the Supreme Court, who specifically rejected what LB 28 is trying to do here. This is legislation that is driven to help one person. It has been rejected by the Supreme Court, and I think it would create a precedent where every time an individual would want a different outcome for an incarcerated person, they would ask for a change to the Post-Conviction Act, the DNA Act, or the motion for new trial. And I think that's a precedent that this committee would not want to start. The legislation was presented in an argument 20 years ago before the Supreme Court, and it was rejected. Thank you.
Okay. Oh, Senator DeBoer.
So I want to make sure I understand the arguments here correctly. The verbiage argument, is it your contention that it isn't possible, or just that it isn't currently the correct verbiage? Because I have to say, I feel like we could write something that would probably work, I mean, amongst the people in this room and outside of this room who could work on this. So if you think that it can't be written in a way to create the legislative intent which Senator Wayne suggested, that's one thing. But if you think that it doesn't currently, I think we could probably fix it. So which position do you have?
I have both positions. So the first position is that the way it's written now, I think if you ask yourself, if you just sat down and read that as a judge, it is not clear on either of those. But also I'm here in opposition because I think that such amendment is unnecessary based on the language in the Supreme Court, the Nebraska Supreme Court decision, as I just read from the Ernest Jackson case from 2002. So I don't think that the language is necessary, and I think that it would promote perjury as indicated by the Nebraska Supreme Court.
Okay, so let's get rid of the first argument, because I think we could write it better. If that's a problem, I think you all could consult with us. We could figure that out. And we could get what Senator Wayne wants to have done actually on paper. So the second question of whether or not it would lead to sort of promoting co-defendants to after their own trial. I mean, doesn't that already exist? If a co-defendant is the one who gets tried first, then, and they're acquitted, then in the second trial, they could say whatever they want and get the next however many co-defendants off. Wouldn't that already exist as a possibility?
Well, absolutely, if somebody gets acquitted in a first trial, but this is a bill regarding a collateral attack.
Right, I understand. But I'm saying if the concern is we don't want to have co-defendants perjuring themselves because the first one is going to say, you know, the first one who gets acquitted is then free to take the blame, is basically the argument that you're making. But that already exists in the law, the possibility that someone could perjure themselves to acquit everybody else who was there if they just happen to be the first one who's tried. So, I mean, I get your point, I take your point, but on the other hand, it doesn't really stop that possibility of perjury from happening.
You're right, I guess in it would be incredibly rare, you know, if somebody were to take the stand in their trial and then they would get acquitted. Yes, they could testify in another trial, but the reason why I'm here opposing this is because what it does is before that occurs, this allows a defendant situations where they could, I guess I don't really understand.
So if your concern is that you are afraid that putting this collateral attack in for folks who are co-defendants and who've taken the fifth, etc., and your concern is it's going to lead those previously taking the fifth co-defendants into potential perjury. I mean, that potential perjury exists in the wild, we'll call it. If the order of the defendants changes, then, you know, that changes who's going to have the desire to do it. So anyway, okay.
I guess, and that's, I mean, the Supreme Court, and if you look at the language, obviously would have been aware of what you're saying too. And our Nebraska Supreme Court specifically said that allowing such newly discovered evidence as is in LB28, if you read this, that would be my answer. The Supreme Court said, it's not me saying that, it's the Nebraska Supreme Court said, and not only that, but if you look in the decision, they also say, we note that this conclusion is consistent with the majority of other state and federal jurisdictions, who I'm sure all thought when this issue was brought to them as to whether or not it is necessary to have a motion for newly discovered evidence based on co-conspirator testimony. They were aware of the situation that you're presenting, and all of those Supreme Courts said that it would promote what I just read.
And that, I haven't done the research on all these other courts and what they decided 20 years ago and whether they've changed that in the meantime, but I will ask you this. Does the situation with respect to Ernest Jackson seem just to you?
Well, I don't think I'm a person who's able to say that, but what I can say is that I did handle his Alabama versus Miller is a Supreme Court case that allowed juveniles to be resentenced, and I handled the resentencing for our office, so I'm familiar with the facts of the case. I obviously was not there for the original trial, but I do know that there was a witness, an eyewitness in Mr. Jackson's case, and if you read through the Supreme Court opinion, it goes through the testimony, and that witness specifically stated that
I get
he
it.
saw...
There's other evidence.
Yeah, if I could finish. That eyewitness specifically testified that he had no doubt that Jackson was the person that he saw shoot Perry.
Okay.
So when you ask me, is it just, I don't think that's my position.
No, you're
that
right.
There has been a jury of 12 people that convicted him based on that testimony. In the Supreme Court decision, the defense attorneys brought up sufficiency of the evidence, specifically based on what you're asking me, that this witness, they denied that, and then the motion for new trial was also brought up in the direct appeal. In the juvenile resentencing, which I did handle, the public advocacy handled that, and they argued as a mitigator in that resentencing all of these facts to the district court judge who handled the resentencing about 3 or 4 years ago.
Okay, so you're right. I asked a very inartful question. I'm sorry about that. Let me ask a more specific question. Do you think it is just to not allow exculpatory evidence from a co-defendant about someone just by virtue of the order that their trial came in?
I think exculpatory evidence should always come in, but this is a situation that was based on felony murder. There was an eyewitness who saw Mr. Jackson shoot the firearm. His co-defendant testified that, I have not read Shalimar Cooper Ryder's transcript, but I'm assuming his testimony was as such as that I felt I had to shoot because my life was in danger. Well, exculpatory evidence to me would be DNA. You were not there. This shows that in this particular case, there's evidence that more than one person shot. So just because the co-defendant felt that he had to shoot, I don't know if Mr. Jackson felt that he had to shoot because he didn't take the stand in his defense.
I think I understand your position. Thank you.
Who else? Anybody down here?
I'll-
Did you have a question?
I do in a minute, but I'm going to think about it.
Senator McKinney.
So you were the prosecutor representing the state in the resentencing of Ernest Jackson?
I'm sorry, I didn't hear the very end of what you said. In what?
Did you represent the state against Ernest Jackson in his resentencing?
In the juvenile resentencing, yes.
Okay. I guess one question I got, before today, why didn't your office work with Senator Wayne to craft the correct language or work out the kinks of this bill?
I can't say what contact Senator Wayne had directly with my office. All I know is that I was asked through the lobbyists of the Nebraska County Attorney Association to come here based on my experience with collateral attacks. And I'm here. My boss, Don Klein and Brenda Beadle, also asked me to be here. I personally have not been asked to help clear up the language or to draft anything on this. As for anyone else, I can't testify to them.
Are you aware of anyone in your office offering any support of Ernest Jackson in his pardon process?
I'm not aware of anyone being asked to do that, and I'm not aware of any part of his pardon process.
Do you think your office would be open to doing so?
I can't speak to that.
All right, thank you.
And again, I'm here, obviously that this LB28, to further answer your question, does not have the name Ernest Jackson in it. I'm here to oppose this because I think it would have long-term ramifications for all defendants in collateral attacks. So that's why I can't testify directly to Ernest Jackson. I'm not trying to evade you.
How do you, in your opinion, propose we deal with situations of injustice in our court systems? If you come here, because my thing is, we update everything in life. Everything gets updated year after year, month after month, day after day. But when it comes to the courts and the prison systems, it seems like that no one's willing to update that system. But if you look at the historical facts and the facts, that are set, there's so many disproportionate rates of individuals being unjustly convicted of crimes across the nation, not only in our state. Why is in our current prison system has an overcrowding issue because of this? Why is it so hard for the courts in the prison systems to open their minds to update the system to improve outcomes for all?
Well, I think obviously that's a way bigger question than I'm here, but I will speak directly to collateral attacks. And I will say that they have evolved, and they've evolved through case law. They've evolved through statutes. A few years ago, there were additions made actually to this statute when you look at that. And so there has been an evolution. There has been amendments and adoptions in the Post-Conviction Act, the DNA Act, and with regard to the motion for new trial. And those are all available to ensure that there is justice, and so that individuals do have the ability, if you can follow through with the requirements of those statutes, if it shows that you are innocent or you can avail yourself, those are all available. The problem with LB28 is that it opens to get rid of the 5-year time frame. I mean, that would just open the door in every single case. There has to be a narrower way to handle that than the legislation as written.
Just an estimate, realistically, how many cases do you think this would apply to?
I have no idea. I don't know how I would be able to know that. I mean, I don't know how many people are incarcerated where there are co-defendants, where somebody was convicted first and another co-defendant either pled, because that could be a situation too where co-defendant 2 takes the Fifth Amendment in co-defendant 1's trial and then pleads, and then is willing to testify in co-defendant 3's trial. I mean, there's a lot of scenarios. I have no idea.
I guess my question is, if you're making the argument that it would open the floodgates, I would like to see how many cases this applies to. If you could give me that data, if not, I understand. But if possible, I would like to see it.
And I apologize if I created any confusion when I said floodgates. If you look at there's 2 amendments in LB28. One's to 21-101 and the other's to 21-103. And what is in 2103 is that it eliminates the 5-year requirement for a motion for new trial. And that doesn't eliminate it just for situations like Ernest Jackson where there's a co-defendant. It would eliminate it for all motions for new trial. So that's what I was referring to with the floodgates.
If that's fixed in the bill and it limits it just to these situations, would you be okay with it?
Can you restate the question?
If it was adjusted within the bill to limit it to these type of situations, would you be okay with that language?
I would say no, because I'm not okay with the language in 2101.
All right, thank you.
Senator Pansy Brooks.
So you said that for justice that it should be more narrowly drawn than lifting the 5 years. How long? I mean, so you think justice is served after 5 years and that's it? That's the bright line. And if we find out information later, then too bad for the person that was convicted. Yet meanwhile, we go back and exonerate people after they've died posthumously. I'm just interested in what this theory is that justice has a 5-year window.
Well, that's not what I stated. Right now, the statute as currently written that was passed by the Nebraska State Legislature pre-LB28, that has the 5-year restriction on it. I didn't come up with that.
I know, but you're saying we have to stick to that.
Well, yes, but if you read the statute in the second part of that verbiage, what it says is 5 years unless there's other showings. There is a way to have cases and motions for new trial filed outside the 5-year limitation. What I'm saying is, I think the way it's drafted now with regard to 2103 is fair, and that allows for these to be filed outside that. And I don't think there's any reason under the change for 2101 why there would be a reason to eliminate the 5 years except for just Ernest Jackson.
Well, we don't know who else might be coming. That's true, and it doesn't seem like there's going to be a lot. But our justice system needs to be just. So the discussion previously was about newly discovered versus newly available. I was looking at my notes that I made. So the statute clearly says newly discoverable and doesn't talk about newly available. I think that's a weakness in our statutes. And why shouldn't that be something that would help us to make sure that our justice system is just?
So
To
what's
use
the
the-
question?
to
I understand
use-
you get the thought, but
To
what's
use
the
newly
question?
available, or to, that's the discussion about changing it. And it's my understanding, I've not read the Supreme Court case yet, I'm understanding that the Supreme Court pointed to the fact that it said that it had to be within a reasonable time after the discovery of the new evidence. And what was mentioned before was, well, there's newly available evidence in a case where somebody who's pled the fifth comes forward and says, now I can. I mean, shouldn't we err on the side of justice and making sure that each person is able to be heard and all evidence come forward, rather than saying, oh my gosh, it was available before and, you know, they couldn't get it discovered because somebody was asking for the fifth. That's not justice. That's not a way to go forward with our system. If we have somebody that's innocent, that is held in prison, can you explain that to me? Why newly available wouldn't be better?
Senator Ginsburg, with all due respect, I'm not trying to be difficult. I researched and prepared to be here to testify regard to LB28 in the small addition that added, as well as striking the language of the 5-year. The language of newly available versus newly discovered is in the statute. It's in the decision by the Nebraska Supreme Court as well as federal and state courts. I was not prepared to sit here and go over every case which analyzes and explains for so many different scenarios as to the case laws when we determine if something is newly available versus newly discovered. I mean, tons of cases, which I've handled. So I can't, that's a very huge question to say why I would think that a statute that's been on the books forever and the case law and the courts have upheld forever. I wasn't prepared to sit here and testify to that today. I think the language that was added, I'm here in opposition of for the reasons I gave, and I don't think it's necessary to strike the language in 2103. As for when the statute was first created in that verbiage, I don't know.
Thank you, Ms. Benson.
Okay, thank you for being here.
Thank you, Senator Lathrop.
Next opponent. Anyone else here to testify in opposition? I don't see, before you get away, I don't see any other opponents. I wanted to allow time for that. I got a question for you though. So what we don't see in here, but maybe what I've experienced reading advance sheets, is that if the court were to take up a motion like this, say Ernest, we passed this thing, Ernest Jackson now hires a lawyer and he's going to make the motion. The court also has to make a determination that whatever this person has to say would affect the outcome, right? So it's not you have somebody that took the fifth in a case before you, he wasn't available at trial, now you get a new trial. Somebody has to make a determination that testimony would have made a difference.
Correct. And so, yeah, there's multiple roles. It's just not whether is it newly available versus newly discovered. Then the second prong is, and that's how you overcome the 5 years, is when you show part of that is that it could impact the ultimate outcome of the trial. Not that just, maybe a jury would have thought. It's like, would that critical information
Clearly. That's a pretty high standard to overcome.
Correct.
Okay. So when we talk about the implementation of the statute, and you said, well, when, like, was that the preliminary hearing or was it at somebody's trial? The reality is, if it wasn't some testimony somewhere that would have ultimately changed the outcome of, in this case, we keep talking about Ernest Jackson, but it wouldn't have affected the outcome in Ernest Jackson's case. Motion overruled, Ernest Jackson continues to sit in the Department of Corrections.
Correct, and you would, I mean, the argument would also be that you look at the evidence that obviously was adduced in Mr. Jackson's case in comparison to what the newly available or newly discovered evidence would be.
And maybe another way to illustrate this point is, if this were to pass and he makes the motion, you're not going to concede it, because there's an awful lot he'd have to overcome besides.
And again, I'm prepared for this particular case, but in other cases where there's been a motion for new trial based on newly discovered evidence, yes, I read through the Bill of Exceptions and I would make the argument, hey, Judge, even if this person said this now, look at all of this.
Maybe
would
the
make it
most
different.
common defense you use in these kind of cases. It's kind of the
Yeah,
so what,
yeah.
didn't make any difference.
Correct.
Okay.
And then the remedy would be that, that's the problem also with the 5 years, is that you have to understand that the remedy would be that, yeah, the state after 20 years, you have to find those witnesses, and that's why it's so important to rely on that prior transcript
Got
as you
it.
brought up.
Okay. Thank you so much for answering the questions and being here today. We appreciate it.
Thank you.
Again, any other opponents to this bill wish to be heard? Anybody here in a neutral capacity? Seeing none, Senator Wayne to close. And as you approach, I will, for the record, we have 21 position letters, all proponent, and we have 2 written testimony offered and filed this morning, one by Spike Eichel with the ACLU as a proponent, and James D. Smith from the Nebraska Attorney General's office, and also on behalf of the County Attorneys Association, and he is an opponent, or his testimony is in opposition. With that, Senator Wayne, you are free to close.
Thank you, Chairman Lathrop, and I will try to be brief because there were some interesting points and some good points that are brought up. One, if the idea of the floodgates opening, we don't know how many cases are like this, and so we don't know if the floodgates will open, but to Chairman Lathrop's point, there's still a process in which a judge has to decide if it's material, in addition if it will make a difference in the case. To Senator DeBoer's about language and things we can do, I'll give you one example that we've already drafted an amendment, but I do apologize to the Judiciary Committee. I'm sorry that this hearing has to be the compromising process for me to understand their actual issues. I was just told they were going to be against it and not really a whole lot of issues as far as the bill itself. But as far as the 5-year look back, you can limit it to Class 1, Class 1A, Class 1B, and Class 1C felonies, and most of those are all up to 50 years or life. Why should 5 years apply to somebody who is sitting in there for life? Now, if it's a 5-year sentence, then obviously the Class 5 or the statute of limitations on 5 years makes sense. So I think there is language we can come up with to make this work. But the key difference, and I will work on an amendment actually starting today because it's such an important bill that I want to get to the floor, it isn't the constitutional right that is being asserted the issue. It's the actual testimony under oath as evidence that is the new evidence. And underneath that testimony, it's under oath, subject to cross-examination. That's why it's allowed to come in any other hearing. That's the critical piece of evidence that is failing to admit or to be, I think, understood by the opposition. In addition to that, in the Ernest Jackson case, and I tried my hardest not to talk about it, what's failed to be mentioned is the person admitted to shooting also admitted to Ernest Jackson not being there twice under oath, twice under cross-examination, and was part of the reason the other individual was not guilty, because he also testified that I wasn't there. Now, why is this important about the Fifth Amendment for those who don't practice? It's not like on TV. And what I mean by that is, if you know that witness is going to take the Fifth, you have an ethical obligation not to put that person on the stand. If you do, it's an automatic mistrial. Because the prejudice of having somebody plead the Fifth, especially in a criminal trial, will all but assure serve as a not guilty verdict to the one who is on trial. So the Supreme Court says you can't even do it. So what actually happens is, either in the situation with Ernest Jackson where their attorney asserts it, maybe even signs an affidavit, sometimes a judge will bring a person in, voir dire, and make them assert underneath oath. But once they assert, the jury never gets to see that person, never gets to hear that testimony. Because no good attorney, one, is going to allow that person to be called, but two, the prejudice of a Fifth Amendment waiver or a Fifth Amendment assertion is so prejudicial that it can't happen. And it's actually misconduct on the part of the attorney to allow that to happen if you know it's going to happen. So we're actually talking about the testimony under oath. So we are not allowing the testimony in as evidence. We aren't saying that anyone can come back years later and say, I have a witness who didn't say anything. We're actually talking about the testimony and not the witness. And I have no problem bringing an amendment to clear that up. But the biggest issue or the underlying context of this bill is that there's a fundamental principle in our Constitution and our judicial system that it is about justice. Not about court efficiencies, not about how many hearings, not about everything else, but justice. And our foundation in our community is best served to the community when the individual rights are maintained and ensured. This is not about Ernest Jackson. Ernest Jackson is just a byproduct of an unjust process. And I have to remind this committee that a pardon is about forgiveness, not about innocence. And what we're trying to do is allow somebody and those who are in a similarly situation where they have the lowest docket or somebody asserts a Fifth Amendment right and later comes back under oath and testifies that is new evidence that should have been heard or should be heard in a new trial. But there's still an obstacle you have to overcome. And that's following the motion, as Chairman Lathrop said, and making sure that the judge still even grants it. A just judicial system is about allowing someone to prove their innocence. Even though the burden is on the state all the time, if they have evidence out there that they can later come back and say, here we go, look, that person should have their day in court. And with that, I'll answer any questions.
I don't see any questions, Senator Wayne.
Thank you.
You'll let us know after you work through whatever you got to work through.
I'll be working through it today. Thank you.
Okay, thanks.